The information provided in this video is intended to be general in nature. While we strive for accuracy, the legal landscape changes rapidly. We are not your lawyer, and the information presented here should not be viewed as a formal legal opinion. Always seek the advice of a qualified attorney before taking any action based on the content of this or any information not given to you by your licensed attorney.
Turn on any national news network, and you will inevitably see the spectacle of a high-profile self-defense trial. These cases dominate our headlines, sparking intense debates about when a person is legally permitted to take a life. When we watch a trial like the state of Florida versus George Zimmerman, courtroom arguments almost entirely revolve around the defendant's internal state of mind. The jury is asked to figure out what the shooter was feeling in that exact terrifying moment. We see the same pattern in cases like Daniel Penny's subway chokehold trial in New York. The defense hinges on the individual's personal, subjective perception of an imminent threat. Over time, this relentless media coverage trains the public to accept a specific legal premise, that the right to self-defense is ultimately tied to your individual emotional truth. We are led to believe that if you genuinely panicked and feared for your life, the law will protect you. While these stories feel like universal lessons on the right to survive, they are actually anchored in specific state laws. In a courtroom, what feels like a common-sense reality often stops at the state line. A legal strategy that successfully secures an acquittal on cable news or in a New York courtroom holds absolutely no weight if you live in Arizona. The justification of violence in the United States is split into two distinct legal universes, the subjective and the objective. Knowing where your state draws the boundary line is the difference between walking free and a verdict that shatters your life with a murder conviction. To understand this divide, we have to start with the subjective prong of self-defense. This is a purely internal inquiry. It asks one question: did the defendant genuinely believe they were in danger at the moment they used force? Many jurisdictions, including New York, use a hybrid model that explicitly requires juries to evaluate a violent encounter through this highly personalized, subjective lens. Under a hybrid model, the jury is instructed to step into the defendant's shoes. They have to consider the individual's unique life experiences, their physical limitations, and any past traumas that might have shaped their perception of danger. The landmark precedent for this comes from the 1980s, when Bernhard Matz shot 4 teenagers on a New York subway. The court ruled that Goetz's prior history as a victim of a mugging legally shaped his perception, giving him a valid basis for his fear. The court also allowed environmental factors specific to the defendant's perspective to carry legal weight. The fact that Goetz felt trapped inside a moving, confined subway car became crucial to individualizing his claim of self-defense. Some jurisdictions go even further by recognizing a doctrine called imperfect self-defense. In these states, if a defendant held an honest but totally irrational, objectively unreasonable fear, that subjective panic can actually mitigate a murder charge down to a lesser offense, like voluntary manslaughter. Hybrid and subjective legal systems prioritize psychological reality. They allow human flaws, anxiety, and idiosyncratic viewpoints into the courtroom to explain, or at least partially excuse, the use of lethal force. The contrasting standard operates under an entirely different logic. This is the objective test, and it centers completely around a legal fiction known as the reasonable person. The reasonable person standard strips away what makes a defendant unique, disregarding personal trauma or panic. Instead, it relies on a cold baseline, the ordinary, prudent citizen. The jury asks, in the exact same situation, would this hypothetical rational person have reacted with lethal force? This objective standard acts as society's critical checkpoint. It ensures the natural right to self-preservation does not devolve into a blank check for unchecked, personalized violence. Which brings us to the rigid statutory framework of Arizona. Arizona law, specifically statutes 13-404 and 13-405, operates strictly on the objective, reasonable person standard. The statutes state that force is justified only when and to the extent a reasonable person would believe it is immediately necessary. Furthermore, Arizona completely rejects the doctrine of imperfect self-defense. Your subjective fear, no matter how genuine it felt at the time, cannot be used to mitigate a homicide charge down to manslaughter. This creates an absolute all-or-nothing reality. If an average, reasonable person would not have feared for their life in that exact moment, your genuine personal terror is legally irrelevant. In an Arizona courtroom, bringing up your unique psychological reality or your past trauma is useless if your actions ultimately diverge from what the broader community deems reasonable. These two systems prioritize different values. One allows for the messy reality of human panic. The other demands a uniform standard of conduct, regardless of the individual's stress level. A subjective model allows a defendant's private anxiety to dictate when lethal force is acceptable. If you feel fear, the law might excuse it, even if that fear is detached from the reality of the situation. Arizona's objective model replaces that private standard with a public one. It creates a predictable boundary by requiring that a neutral observer would agree the danger was real before violence can be justified. This removes the authority to judge a threat from the individual and hands it to the community. In Arizona, you are not the sole arbiter of your own actions. The jury is. But Arizona's strict adherence to the objective standard does not mean the state is universally hostile to claims of self-defense. For instance, Arizona has a strong stand-your-ground provision. Because the law explicitly removes any duty to retreat, the geographic circumstances where a violent response is considered objectively justifiable are significantly broadened. The state also enforces a crime prevention statute. Under ARS 13411, if you use force to stop a violent felony, like a home invasion, the law automatically presumes your actions were reasonable. Instead of you proving you were right, the state has to prove you were wrong. Arizona restricts who gets to define the danger, demanding it be an objective, reasonable standard. But once that danger is verified, the law aggressively protects the defender's right to react. Do not build your understanding of self-defense from national headlines or the outcomes of out-of-state trials. In Arizona, the mirror of justice reflects the standards of society as a whole. If the reasonable person does not see a lethal threat, neither will the law.
Thanks for watching. If you're ready to get your Arizona CCW, our online class makes it simple. Visit class.concealedaz.com. Any device, self-paced. No live fire test required. Get started now at class.concealedaz.com. Stay safe. Stay legal.
We often have promotions and discounts, so please contact us directly at info@concealedaz.com for special pricing and promotions.